There we go. Okay, so we're covering trademarks and copywriting and what you need to know in order to save yourselves a lot of time and grief and frustration and money. Because if you end up going down the wrong path, and you're not sure whether you should be trademarking a piece of intellectual property or whether you should be copywriting it, you could end up spending a lot of time and effort actually sort of chasing your tail. Actually is what can happen. So where I'm coming from with this is that this is a question I get asked constantly. People email the CMA and say, I've got this course, I don't know whether I need to trademark it, or I've got this new discipline that I've created. Do I need to trademark it? Or I've got this new, I've just created my logo. Do I need to copyright it? And the answer for all of those is no, you need to do the other thing. So this is what I'm hoping to do today, is to actually explain to you what the differences are between copywriting and trademarking and how to know the difference, so that it sort of streamlines you in protecting your really hard, your hard work, your blood, sweat and tears. Because let's face it, when we create new trainings, if we create a new way of approaching a healthcare discipline, then it can be very, very difficult if we then find that, and this does happen, and over the last nearly 30 years in the field, I've seen it happen time and again, where people have created courses, for example, and people have gone off and students have gone off and basically nicked the material. It happens, it really does. And so this is what I don't want you to have to go through that heartache, because when we create these things, we do so, we put our hearts and souls into creating things, don't we? And when it gets abused, used, or dare I say stolen, it's really soul destroying. It's really, really upsetting. And so what I'm hoping today is the information I'm going to be sharing with you is going to sort of circumvent all of that stuff and protect you. So what I'm going to do first of all, and actually because we're a reasonably sized group, please feel free. I'm going to make sure I've got my chat box open so I can see any questions. And I'll tell you what would be really brilliant would be if you could just let me know where you're joining us from while I go ahead and in the chat room. Sorry, let me just get rid of that. Okay, and I'm going to decline that. And I'm just going to go into do not disturb mode. Okay, alrighty. Okay, so that's that. Now, let me know where you're from in the chat box while I launch the share screen, because I always love to know where people are coming from, because very often we'll have people from all over the world on these sessions. So please, 1 a.m. local time, Carolina from Australia. You see, this is what I was saying. My goodness, wow, that's fantastic. We've got Janet from Roydon, Essex. Lovely Tony from East Kilbride in Scotland. We've got Wayne from Padiham, it's one of those names, isn't it, that place names where it could be pronounced different ways. We've got Tula. Hi Tula from Chester, originally by way of Finland, obviously. And we've got Harjit from Burnham, just up the road from me. I'm in Berkshire as well at the moment. Tina from Horsham, Sue from Sawbridgeworth in Hearts. Borislav from Bulgaria. Hi, hello. I love your country. I love your country. I love your food. I love your people. I've had great times in Bulgaria. Chanan from Lampita, I think, isn't it? Linda from sunny Bournemouth. Yeah, we've got sunny Berkshire today as well. And we've got Claire from York, Phyllis from Exeter, and Kane, hi, Kane Leatham, hi Kane. You need to rejoin the CMA, Kane. We've got lots and lots of exciting changes and so on that have come on board since you were last with us. So I shall talk to you about that at another time. And yes, you do. It's so good to see you here. How lovely. And Judith from Exmouth. Well, this is absolutely brilliant, everybody. Thank you so much. Right, let me just go into share screen because I want to start. There we go. This is where we need to be. So let's share this. This is what I've created for you. And I'm going to pop us just there, and I'm going to minimize this screen here, actually what I'm going to do, I'm going to go big again, and I'm just going to go back to, I'm going to pin myself and spotlight for everybody. Otherwise, it all gets a bit difficult, doesn't it? When Zoom does that weird thing when it starts jumping around and so on. But here, I'll stick myself up here out of the way. So, okay, so let's crack on without further ado. So, copyright versus trademarks, how to protect your work. What I want to do, just by the way, is can you all see the screen? Can you give me a thumbs up? And can you see me in the top corner? Yep, okay, terrific. That's great stuff. So we're on track. So why intellectual property is important. This is the first thing we really need to get our heads around. Intellectual property, IP as it's known, is anything your business creates that derives from your own brilliant mind, your intellect. So anything that you come up with, anything that you create, any original work, this is your IP. You own your IP. You have the rights to it, okay? Remember that your IP, your intellectual property, it could be a course, it could be a new way of doing a complementary medical discipline, it could be an artwork you've created, it could be a piece of music you've created, it could be anything that you have come up with and is original to you. So it may not have a physical form, however, IP covers everything from inventions and prototypes that could be turned into, this is important, marketable goods and services, through to your brand, such as logos and marketing materials. So anything that you've created that you lay claim to, okay, is something that you could copyright or you could trademark. And we're going to talk about the differences between the two. And we're also going to come on to talk about the costs involved. We're also going to talk about how to shortcut things and whether you do need to actually spend money to protect your IP. So I'm always one for don't spend the money if you don't need to. So I'm going to come on to that later. Okay, I hope I've covered everything for you today. But please bear in mind, protection is essential. It's vital to secure your intellectual property. It's valuable and can be sold, licensed, and even used as security for investments. So if you develop a particularly valuable brand, let's say the CMA, the CMA, the logo that is our registered trademark, is a valuable item. And so, for example, in the past, and we've also got some coming up, where we've got some of our approved suppliers who've created products and they've said to us, can we use the CMA logo, the registered trademark? So this here is our registered trademark. If you can see my mouse circling around at the bottom there, that device is our globally registered trademark. And they've said, can we put the CMA logo onto our products to show that we are CMA approved suppliers? And the answer is yes, but it's a licensing deal. It's a completely separate thing from just being a CMA approved supplier. Or let's say you're a practitioner and you've got a product range. You can't then just put the CMA logo on your product and say, oh, I'm a member of the CMA, because that logo, that trademark, would infer, if it was on your product, that the CMA had endorsed your product. So for us to endorse a product, which we rarely do, because if you think about it, the liabilities of us endorsing a product are massive. So we tend to be very careful and only work with a select few. So the reason I'm telling you all this is because I'm thinking that, it's useful information for you, because if you've developed a very valuable brand, like the CMA, for example, it is something that you can utilize to actually raise capital. You could actually use it, as I said earlier, as security for investments. So if you were, let's say, doing let's say you were getting some angel investments, if your brand is really valuable, then the investors will go, okay, we see the value in that brand, so we will lend on the value of that logo, that brand identity. So, this is why it's so important, okay? It really is, these things are worth money. So for us, with our licensing deal, if somebody said to us, oh, well, I've got this new product, I would love to have the CMA logo on it, which would, of course, imply an endorsement of this product, we would then have to do our due diligence researching the product, and we would then create a licensing agreement with them that would cost them obviously many thousands of pounds, because the logo is globally recognized and. So you see where we're coming from. I hope that makes sense. If it doesn't and it needs further explanation, just drop me a little message in the chat. Okay. The next thing is, if you don't protect your IP, you could lose out financially. A competitor may steal or copy your IP by creating a similar logo, or they could create a similar practice identity. They could create a similar or same course. I've seen it happen, as I said earlier, where people have, trainers, people running courses have contacted us saying, oh, I created this course. This is my IP. I've copyrighted this, or at least I think I have. And that's always the crux of the matter. I think I have, and I'm going to tell you how to do that in a moment. But this student of mine has taken all my course materials, and now they're running the course as if they created it. Honestly, it happens, which is why it's so important that we're having this discussion today. So if somebody, let's say they haven't stolen your course, but they've stolen your logo, for example, then it could confuse your clients or potential clients to the extent that your practice or your school or your retreat or other business could lose sales. So this is why we've got to make sure that you are 100% protected and you know what you're doing. So first of all, let's just discuss the difference between a trademark and a copyright. Trademarks and copyright both exist to protect your intellectual property. So I think I've rammed that home well enough now, so you know that. They are used to protect different types of assets, and they work in different ways. They also offer different levels of protection. So what is a copyright? Let's deal with that first of all. Copyright determines the rights people have over the original work they originate and create. Okay, so whether that's a course or whether that's a new way of doing a discipline, or whether it's a recipe or a poem or an artwork or whatever it is, that's something that can be copyrighted. It covers all unique creative works such as graphic designs, software, content, photography and film, video and audio recordings, even adverts. I mean, I've lost track of the number of times that people have literally used my blood, sweat and tears sales copy for training courses and whatnot, and they've actually turned it around and literally used it word for word to sell their own sort of, you know, copycat Me Too type courses. It's ridiculous. They do say, don't they, that flattery, so imitation is the most sincere form of flattery, but it's blooming annoying when it happens and they're just basically nicking your stuff. What my answer to that is always just, well, you know, it happens. Move on, innovate, get better, raise your game, look at what you could be doing better, and just do it. Okay, don't get your knickers in a twist. Don't get upset by it. If somebody is insecure enough to have to literally copy your stuff word for word, move on, unless it's your course or something like that. I'm just talking about adverts now and you know, your website content and things like that. Then just up to you to up your game, you know, so that really is it. However, if you've got content, let's say on your website, that is about the work that you do, that is copyrightable, and that is something we're going to talk about actually protecting. In our field, for example, copyright covers all of the things that we've spoken about just now, plus, as I say, course content and new and unique approaches to therapies. So, for example, let's say you develop a hybrid therapy. So the lovely Christine Westwood, I'm sure most of you have probably got her aromatherapy books, which were written long time ago. But Christine, quite brilliantly, as a fantastic aromatherapist and a brilliant psychotherapist, she created something called meta-aromatherapy, which is a form of psychotherapy that actually integrates the use of essential oils. So she created this thing called meta-aromatherapy, which is absolutely brilliant. So that work, the content is copyrightable, okay? And the word meta-aromatherapy is trademarkable. So we're going to come on to trademarks in a minute, but let's just finish off the thinking behind copywriting. Importantly, copyright covers the expression of an idea rather than the idea itself. So, for example, you could copyright a recipe but you couldn't copyright a list of ingredients. So it's kind of the way you bring things together. So if you say, this is my recipe for brownies, this is Janie Goddard's recipe for black bean brownies, that recipe is copyrightable by me. So if I create the recipe, it's my own intellectual property. I've thought it up, I've experimented with the recipe, I've made it work. So that's something that can be copyrighted. But if I was just to put on the internet, let's say, a can of black beans, oats, trying to think what else is, obviously cacao and sugar, and so, you know, coconut sugar, that sort of thing. All of that is just simply a list of ingredients, and it doesn't turn into anything because I'm not giving the instructions there, and I'm not saying this is why I did it, this is how it works, add this, add that, do this, do that, stick it in the oven, blah, 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 turn it out, blah, blah, blah. All of those things to create this whole, that's the element that's copyrightable. Copyright can be transferred, sold, or otherwise assigned to other people. And usually, this is really important for all of you. Usually, work created by employees is owned by the business or the university, for example. So, for example, if you were employed by a clinic where there are lots of different practitioners, let's say you're actually employed rather than working there as a freelancer. If you're employed there and you come up with some wonderful new training course, for example, the danger is that that could be owned, the copyright to that, because you're employed by these people, could be owned by that clinic. So you've got to be really, really clear if you're working for somebody and you're also creating intellectual property at the same time. You've got to be really clear that you cover this off in your contract, and that, you know, there's no danger of you potentially losing copyright to your works. Similarly, if you wrote a book while you were working for somebody else, there's a very real danger that that other party could own the copyright to your book, your course, or whatever it is. So please be very aware of that. That's something I do want you to take on board and to drive home, because it really is quite, it puts you in a precarious position. So just be clear. If you were to work for somebody, just say, by the way, I'm also working on creating a course which I will be delivering off my own bat, and I want it written into the contract that you do not have copyrights to any of my intellectual property. Okay, really important. I've seen a couple of people I know, one particular doctor I know has a website of his own, and he was putting up wonderful, wonderful, wonderful articles on this website. He was at that time working for a big spa in America as their doctor. And to his absolute horror, the guy who owned the spa said, we're going to publish all of your work on your website under our own brand because we own the rights to that. And actually they did, because he hadn't actually set aside his own intellectual property. So this can be a real sticking point. So, you know, I know I'm going on about this a bit, but it's really important. So now let's talk about a trademark. A trademark is more specific than a copyright. It's designed to protect anything that identifies the goods, services, and brand of a business. Trademarks protect such items as a brand name, a slogan, where it's called a wordmark, and a logo. So we, as the CMA, have got, this is our logo down here, and our wordmark isn't on there, but it's Complementary Medical Association. So we have both of those protected worldwide. Okay, so does that make sense? I hope it does. So the thing about, I mean, I've done these tutorials on logos and whether you actually need a logo. And as practitioners in practice, generally speaking, if it's your practice, I feel you probably don't need a logo as such, unless you're going to start bringing on board lots and lots of other people, and you ultimately want to sell your business, for example, so you'd rather it was more generic. But for example, a good example of a trademarked personal name is, let's say, Les Mills, you know, the fitness people. So that would be an example of when you would use your name as a logo. If you're in practice, working as a practitioner, and you're a sole practitioner, then using your name as the business brand is probably a good idea, because people get to know you, they get to know your website, they get to know anything you're putting out on socials. So they will tend to relate to you, and if you're using your name as your brand rather than a more generic logo. A logo is a very specific thing. There are so plus points and minus points to actually using them. We're not going to go into logos today, because that would be, as I say, is a lecture in itself. I have already done one for you. It's on the Complementary Medical Association YouTube channel if you want to go and have a look at it. But trademarks are very, very specific. They're designed to protect identity. Okay, so for example, for us, Complementary Medical Association is our identity of our business. I hope that makes sense. So this is all getting a bit geeky now, but I just have put this here, and I've made a shortened link because I certainly don't expect you to be able to write this down. But if you want to take a look at the Berne Convention, it's quite a good idea to do so. Both copyright and trademarks are territorial. Now, obviously today, we've got people joining us on this call from literally all over the world, which is absolutely brilliant and wonderful, and thank you. So what I've done, I've put this Berne Convention link, this is the bit.ly link for you down here. So if you go to bit.ly, the link is 3A4ZUAD or 3A4ZUAD, okay? So write that down, go to bit.ly, put that link in, that end link, and you'll find this great big link, the Berne Convention. Both copyright and trademarks are territorial, as I say. For example, just because you've protection in the UK or elsewhere doesn't mean to say you have protection internationally. Each country has different levels of protection. So please go to that link to see whether the country that you're in at the moment has signed up to the Berne Convention. So the Berne Convention was adopted in 1886. It deals with the protection of works and the rights of their authors. It provides creators such as authors, musicians, poets, painters, complementary medical practitioners who are teaching training courses, retreat owners who are creating a beautiful retreat brand, and so on. It gives you the means to control how your works are used, by whom, and on what terms. It's based on 3 basic principles and contains a series of provisions determining the minimum protection to be granted, as well as special provisions available to developing countries that want to make use of them. So again, there's another link there for you. And of course, obviously, after this session, you'll be able to access all of these on the Complementary Medical Association YouTube channel. And if you're watching on YouTube after this session and you're watching the replay, then please just pause, copy that down, and then go and take a look at the Berne Convention. You need to see whether your territory adheres to the Berne Convention to assess your level of copyright protection. Okay, now it has to be said that there are very few countries in the world that have not signed up to the Berne Convention. So most of you today, if not all of you, are fully protected copyright wise, and so you don't necessarily need to worry that your IP may be at risk if you copyright your protection, okay, if you copyright your material, I should say. But you've got to do it in the right way. We're going to come on to that a little bit later. So copyrights versus trademark, how work is protected. Copyright is an automatic right that is assigned to you or your business as soon as an original piece of work is created. So as soon as you sit down at your computer and you write your course manual, or you write your wonderful information on your website, or if you write a brochure, or if you design a beautiful retreat and you've got a retreat page up on the internet, anything. So as soon as you write it, it's copyright to you, okay? You don't need to register for copyright protection, and all the rights offered by copyright protection apply straight away. So it's really important for you to understand that it's very, very immediate. However, what I would say to you, a little caveat, is a little tip is it's a good idea to add a copyright symbol to any creative work you produce, as it makes it easier to take legal action should somebody use that work without permission. Consider doing the poor man's copyright and sending the piece to yourself either physically or virtually. So let's say you create a training course, okay, and you want to copyright that training course. Well, it used to be that you would print it all out and then you would put it into an envelope and send it to yourself with a stamp on it, obviously to go through the post, and then you don't open it, because that means that what's in that envelope will have a date mark on it, okay? And it will show, because it's unopened, it will show that if you ever did need to protect your work and take somebody to court, then you would be able to go along with that piece of evidence. It shows that the contents of that envelope were sent to you on that particular day. So that is evidence that you created that work on that date. And so that proves your copyright, that you own that material. However, happily, nowadays, things are so much easier. As soon as you sit down on your computer and you start creating something, as you know, your computer will date stamp that material. It will date stamp the start of it, it will date stamp the end of it, or the date that you last saved it. So you can always prove just by saying, well, look, here's my document, and you go into the properties, file properties, and it will actually show you the properties of the document, and it will show you the date that that document was started and the date it was last saved. So it proves that you own the rights to that work. Much simpler than sending yourself in the post, but you know, that can still be done if you want to go really old school with it. So trademarks, let's talk about trademarks now. They're different. In contrast, trademarks must be registered to have protection. In the UK, for example, and of course I know that we've got people joining us from all over the world, but I'll deal with that in just a moment. But in the UK, for example, you must apply to the UK Intellectual Property Office to register a trademark, and the process should take around 4 months if there are no objections. In other countries, Google your Intellectual Property Office for details of whom to approach. It goes without saying, of course, that your trademark must be unique, and during the registration process, you can use the symbol TM after the item you wish to trademark and the symbol R, meaning registered, when the trademark has been registered. Once your registered trademark has been granted, you can legally prevent others from using or copywriting, or copying your trademark. Now, okay, let me tell you how this works for me. I've got several trademarks out there in the big wide world. So let's say the CMA trademark. Now, the CMA has activities in various sectors. So when you trademark something, you can do it yourself, or you can employ a trademark lawyer. I personally, if it's the first time you're doing it, I would save yourself a lot of time and aggro by using a trademark lawyer. And they will do all of the research for you, which saves you from having to literally search worldwide in every country to see whether your logo or your name is being used. It is very, very, very time consuming. And also, if you're using a lawyer and they make a mistake, they are indemnified against suits. So it means you can sue them for making a mistake and dropping the ball. However, let's say you've gone through a trademark lawyer, they've done all the searches, they've done all the design registration, they've worked out which countries you can trademark in, they will advise you accordingly, they'll tell you which classes you can trademark in. So for example, the CMA is trademarked in, just a few off the top of my head, training courses, teaching, books and publications, magazines, online and offline, membership services, of course, because that's our main thing. And so we've got various classes. So these are the areas you need to look at quite carefully. And this also is where your trademark lawyer will come in. They will actually say, okay, well, what exactly are you trying to achieve here? What are you doing? What are you offering out into the big wide world? And what might you want to offer in the future? You know, have you got other things coming down the pike that you are going to want to do? If so, trademark it now, because it could be really frustrating if somebody else comes along with a very similar trademark and grabs that particular class. So I would always say err on the side of more classes rather than fewer, and also go for as many countries globally as you possibly can. If you suspect that you might be working internationally, for example, we're completely global, you may or may not be. But if you're running a course, and because of the way that COVID has caused most, if not all of us, to have to jump online with the trainings and so on that we offer, then you do really need to trademark anything you're doing globally, because otherwise you do run the risk of somebody coming along from China, for example, or Timbuktu or wherever, and just saying, oh, that's actually a really good brand. I like that logo. I'm going to do something similar, and they're not in this particular class that I want to trademark, and so that you would lose out. Something that happened to us recently was that there was actually, fun enough, interestingly enough, a Chinese company that was trademarking CMA, and they were in electronics and various other things that we're not involved in at all. And I said to the trademark lawyers, do we need to object to this? And they said, yes, you do. You need to file an objection, which we will do for you, for a fee, obviously. Because he said the thing is that if they get CMA as their trademark, they could then, somewhere down the line, start to infringe upon your classes. And there really wouldn't be much that you could do about it. It would just be a terrible legal hassle, and you'd have to end up fighting it. It would cost a lot of money. So my advice to you is do a short, just do as many classes in as many countries as you can, and then at a later date you can decide that you really don't need them, and you can just discard them if necessary. It costs about, well, last time I did not the CMA but a different trademark, it costs about £4,000 to trademark something, but that's through the lawyers, okay? If you go through, let's say, the UK Intellectual Property Office or equivalent in your country, then it's probably about £500, but the problem is you've got to do the legwork yourself. And I really question whether you would spend more than £4,000 of your valuable time actually just trying to chase your tail all over the world. So I personally would tend to, if you're going to trademark something, I would tend to make sure that you go through the lawyers. And you can actually, at the UK Intellectual Property Office, they're really nice people. You can phone them up, you can speak to them, you can explain exactly what you're trying to do, and they will help you and they will point you in the right direction. They're super, super friendly. Sounds weird, doesn't it? Because you'd imagine to be really stuffy and, oh no, you can't possibly come and speak to us. They're brilliant. They're really super helpful. And they'll also point you in the right direction to find trademark lawyers as well, really good ones. So yeah, so that's just a little aside there. As I say, your trademark must be unique, and during the registration process, you can use a symbol TM after the item you wish to trademark, and then the symbol R after the trademark. So I think it's important to know what you can use when. I'm going to come on to that in just a minute. And then obviously once you're trademarked, if you choose to go that route rather than copywriting your intellectual property, then you can legally prevent anybody from using that trademark, which is really rather nice. So further, copyright versus trademarks. How long do they last? Well, copyright is automatically assigned upon creation, as we just said. It also has a defined shelf life before it expires. However, the good news is copyright protection doesn't expire until 70 years, or in some jurisdictions, 90 years after the death of the creator. So after we're dead and gone, our IP is protected for 70 years, okay? Or, as I say, 90 years in some places. After this, the work falls into the public domain and becomes free for anybody to use. People and businesses can use, modify, and sell work that is in the public domain without having to seek permission. Having said that, though, because copyright and intellectual property, as I said right at the very, very top of this tutorial, intellectual property is valuable. It does have value. So you could actually will intellectual property to somebody, family member or whomever, whoever you want to carry on with your work, and they could then legally own that material, and they could then, it could then be, part of your estate. So, it doesn't have to just fall into the public domain. But then again, my question is, 70 years after one has expired, do we really mind anyway? I don't know. That's a call for us as individuals. I don't think we can spend time debating the pros and cons. Okay, so trademarks, though, can last indefinitely if they are actively used and renewed. In the UK, for example, and I know it's slightly different in other countries, but it's all similar. It's not completely different. A trademark must be renewed every 10 years to ensure it's protected. There's no limit to how often it can be renewed. We just renewed the Complementary Medical Association trademark. And I did that, just so you know. Now, here's how I'm going to save you quite a lot of money. So if you use a trademark lawyer, when it's time to relicense your trademark, renew your trademark, your lawyer's going to come back to you and say, hey, guess what? We can renew your trademark. It's just about to expire. And, you're in this class, this class, this class. Would you like us to go ahead and renew it for you? And they'll charge you about the same again. So what I would suggest you then do is not go through your lawyer. If you're happy with the classes and the territories that you're trademarked in, I would then go to your trademark office, your intellectual property office, or whatever it is in your country. And that's when you should do it yourself. So I renewed the CMA trademark for somewhere between £500 and £1,000 because I didn't want any changes to any of the classes. So I just kept everything, kept the status quo, everything as it was, and it saved me about £3,500 to do that. Okay, so that's when you don't use the lawyers. If you don't actively use your trademark within a 5-year period, such as on brand packaging or in marketing materials or on your website or whatever, it can be challenged as inactive and removed from the trademark register so that somebody else can come along and use that trademark. So make sure, if you're going to go to the trouble of trademarking something, that you do keep it active, unless you really don't want it. Okay, so copyright versus trademarks, active use. Copyright protection does not require that you actively use the copyrighted work. So a copyrighted work could be, let's say, an article on your website. You don't have to keep refreshing it. You don't have to keep saying, hey, here's my copyrighted work. It's still relevant. It's still active. Once it's written, as I say, it's copyrighted, especially because you've got the actual hard evidence about when you started, when you created it. So once it's there, it's copyrighted. Your copyright remains intact for the entire duration of the copyright period. So that's right until 70 to 90 years after you've passed away. You also don't need to do anything to ensure copyright protection. You can choose to enforce your copyright at any time during the copyright period. My question to you really, I suppose, at this point is there any point in enforcing copyright? Let's say you've written a training course and your student has run away and is claiming that they own that course. Yes, absolutely, you should challenge that. You can go to the small claims court depending on the amount of value that you put on your course. If your course is extremely valuable, as some courses are out there, I mean, I know a couple of, oh no, more than a couple, actually, now I think about it, I know CMA training schools who are turning over many millions of pounds. And so for them, if their course was stolen and passed off as somebody else's, that's worth millions of pounds. They would then they'd be well within their rights to go to court and to make sure that that person does not use that work. So that's what I'm saying is, these things can be worth a lot of money, and they don't even have to prove that it's been in consecutive use or anything like that, and continuing use, because they can prove that they wrote it. So I know I keep repeating that, but it's really important to take that home. If, let's say, however, it's something along the lines of a piece of sales copy, as I said earlier, let's say you're promoting your new course and somebody goes, okay, I'll give you a real world example. So I was promoting a course on public speaking and how to grow your practice by going out and giving talks. And it's a live workshop, face-to-face live workshop that I teach, and I will be starting again now that we're all starting to all be allowed to be back together again, because I think there's nothing better than having live events. Online is great, but live events are fabulous, as we all know. You get that group energy going. Now, to my absolute surprise and horror at the time, there's a personality in our profession, who literally lifted my sales copy for this course word for word and was trying to get into this profession. She doesn't have a particularly, she's not particularly renowned, or she's kind of in the profession, she's not particularly renowned in it, but she is a well-known person, a personality. Anyway, she'd literally copied my work word for word, but that was just sales copy. And so for me, I'm not going to take her to court for nicking my sales copy. All it's saying to me is, okay, fine, well, that's out there. This person is so insecure that they cannot actually think up their own sales copy. They obviously think your sales copy is really, really good. So just innovate, just up your game. Don't even worry about it. If people are going to be that petty and sad, then just move swiftly on. It's a bit like trolls. Just move swiftly on. That's their stuff, not yours. It doesn't say anything about you, it says everything about them. So pick your battles. I think that's really what I'm saying. Okay, so now let's briefly talk about, we're coming to the end, and I'm then really happy. I can see the number of questions in the chat, but I can't see the chat at the moment while I'm sharing my screen, so I will come back and we can then have a chat about this all further. So use of the symbols, what do you use where? When you've got articles, let's say on your website, or at the bottom of your website, you can put a copyright symbol, this one, okay, and that actually just shows that all of the work, and you can say all work on this website is copyright to Joe Blogs, blah, 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 and that will actually, you don't even need to put dates on. I tend to, but you don't need to. There's no need to, quite honestly. Just put this work is copyright to. All rights reserved. So that's all you need to do. That is simple as, really, really simple and straightforward, and costs you nothing to do this. Okay. If you are applying for a trademark, then this little superscript, TM, is used as superscript. So you've got your words, and then just above them, as you know, sitting at the end, says TM, trademark. Then if you have then registered, you've gone through the process and you've got your finally registered trademark, happy days. It's lovely actually when your trademark comes through. It's very special. Then you can use the R in a circle, and that means it's a registered trademark. Okay, so all very simple. I'm assuming everybody knows how to get these symbols. If you don't know how to get these symbols or where they are, let me know in the chat, and then I'll show you on a document. Okay. What about costs? All right, so costs. It costs nothing to assert your copyright over a piece of intellectual property. You can register your copyright in some countries, but it's not necessary to do so as long as you have proof of the date you created the work. So that means that in some countries, for example in America, they have a body there where there is a copyright agency. And it's federal rather than sort of a state thing. It's actually a global sort of government thing in America, covering all 50 states of the union. So what that means is that if you wanted to register your copyright with this particular organization, just belt and braces, because it seems like a good idea, you can do that. It's going to cost you some money, but you don't have to. Because, as I say, it's your IP, you can prove when you created it. So if anybody rips it off, then you can prove that they created their document later than you created yours. So that's all you would do. If it ever came to court, you would say, well, look, here's the date on mine, and you ask the person to show the properties of their document, and it will show that they created their work after yours. Case closed. It's that simple. It really, truly is that simple. Trademarks, as I said earlier, cost varying amounts depending upon your trademark lawyer's fees, the number of categories you're registered in, and the territories you're registered in. And you need to look at those renewal costs every year. As I say, if you do your first one through a trademark, this would be my advice to you. Do your first trademarking of your logo, brand, whatever, with a trademark lawyer, because honestly, it just will save you time, heartache, and will save you money as well, insofar as what your time costs. And then when it comes to renewing it, just contact the intellectual property office and say, hey, this is my trademark, I'd like to renew it, please. How much is it going to cost? And it's in the UK, it's anywhere from £250, as I say, but because we have more territory, we're global, and our trademark is, you know, several classes as well. It was about 500 or thereabouts, if that. Now I think about it. Okay, so there we go. Just demonstrating you, here end of the sermon, just demonstrating to you. So this is how you would do your copyright on your website, for example. I would just say copyright with your little C in the circle, your brand name, and then all rights reserved. Easy peasy. That's it. It really is as simple as that. Okay, so let me come back to you. I'm going to stop sharing my screen. Okay, lovely. So let me go right back, and I see we've got questions. Lovely. Okay, Taralina says, thank you, it makes so much sense. That's great. Bianca says, this is very useful. Thank you. Kane says, with the self-send, it's recommended to send with registered delivery, as the date when signed gives strength to the evidence. The date stamp on creating the work is good to know. Absolutely, yes, exactly right, Kane. You know, yeah, yes, you could send registered, you could send signed for. Tracked is always another good one as well, because you've then got the paper trail. Remember, with tracking, you know, you've got your, if you go to the post office and you send something tracked, you've then got that little tracked receipt. Clip, when the envelope comes through to you, clip that on the envelope, keep it, make sure it all stays together in case you needed to use that work. It is a little bit old school to do it this way. You don't have to, but you know, if you're like me and you sort of do belt and braces to protect your you know, blood, sweat and tears, literally your blood, sweat and tears, then you know, I really do think, yeah, why not? Why not just do everything you can to protect your work? Lovely. Janet says, this is so useful. Great. Kane says, can you please cover the difference in trademarks for a logo, symbol versus a name? I did my own trademark process and it's very time consuming, but I wanted to be specific about my classes 41 and 44 and wording. Absolutely. There are two things that you can do, guys. So when you're very specific about your classes, you can phone up the IP office, the IPO. And as I say, they're really, really friendly, and they will talk it through with you and help you to decide, if you do decide to go the self-trademarking route. I don't know, Kane, whether you would recommend anybody tries to do it themselves. I personally wouldn't, and as you say, it is time consuming, but you can be so specific. If you go through a trademark lawyer, you can be so specific about your classes, and I think using a lawyer is a shortcut. It's one of those times where I would say lawyers are useful. So my sincere apologies to any lawyers watching this. No, I have to say I've had some brilliant lawyers and they have actually helped out in all sorts of different ways. Kane, to answer that question, the difference in a trademark for a logo or symbol versus a name, what you've got is you've got something called a wordmark and you've got a logo. So we've got both. So the words Complementary Medical Association, that's a wordmark. So we've got that registered as well. And we've got the CMA logo with the Vitruvian Man, with all of the background, all of that is trademarked. Okay, so that's your trademark and your wordmark. We actually did both. So when I now, actually it's a good question, Kane, because now I think back, I actually think the £4,000 that I first spent was, in fact, it was for both the logo and the wordmark. So everybody, you could extrapolate from that if you just wanted to trademark a logo, then it's probably going to be about half the price, and you might not want to do it globally, and you might not be in as many classes, you know, so it is always different. So, you know, I'm just giving you ballpark figures, please remember that. And, you know, it would be down to you to have a chat with your lawyer, or if you decide to go it alone, good luck to you. I wouldn't do it. I wouldn't do it. Hats off to you, Kane, for giving it a go. Okay, Kane says, I've known two people, one who is a well-known celeb, who were students of mine, who stole material and passed it off as their own. I also had someone start a business with the same name, GB Fitness, offering many of the same services. I put an end to all those situations, so this information is very useful. Yeah, it happens. I've had so many people just this last year where, and it's really frustrating, because you will appreciate as trainers that you've got somebody that comes along to your course, and what they'll do is they're a new student, they've got no experience in complementary medicine whatsoever, and they will do your course, they'll get your course material, then they'll bugger off and actually start running your course as their own. It is so frustrating, and Kane, I'm so sorry that you've had that experience. It's really, really, really painful. Especially as, you know, I know you have been in this profession. So for those of you who don't know Kane, he's a really, really, really well globally respected fitness guru. And I don't use that term lightly. Kane is the man. He is brilliant and fantastic speaker if you ever get to see him speaking. And so I can imagine, Kane, how incredibly painful that must have been for you, and annoying and angry making and so on. But I'm glad you were able to sort it out. Can you say actually how you sorted it out? I think that would be really useful for people. One of the things, just talking about a couple of ladies who had their courses nicked by people with absolutely no experience in the profession, aside from the fact they did these people's courses. The students, what tends to happen in the real world is that these students that take courses and think they can do it actually have got no experience. They've got no credibility as practitioners. They actually come across as being very flaky and very weak, and they don't attract students. So in the real world, this is actually what happens. So because you guys have spent all your years earning your stripes and you've worked for it, you have that air of expertise. You are the expert in your field. So do you know what? People can sniff out a genuine expert at 20 paces, and they can sniff out somebody who's fly-by-night from 20 paces as well. You know, the public are not stupid. Potential students are not stupid. If they'll look at your website versus other people's, sort of Johnny Come Lately's website, for example. They'll look at your YouTube videos, which I hope you're doing, and they'll look at Johnny Come Lately's YouTube videos, and they know. They're not stupid. They know who's credible and who isn't. So please don't worry if it happens to you, because if somebody does take your material, they're not really likely to be able to make a success of your material, because they don't have the wherewithal, they don't have the in-depth knowledge that you've built over years and years and years. But what could happen, and this is my big worry, what could happen is, because they're rubbish, it could potentially impact on your business. Now, that's where I do worry, which is why you would probably need to go to something like, if you want to keep it really dead simple, small claims court, and there's just basically get a cease and desist order. That's all you need to do, and that will sort them out. Okay, so yes, Taralina says it is terrible. Wayne says, any comments about France and Napoleonic law? Well, I've got lots of comments about France, but that's more to do with COVID. So, no, in all honesty, and in all being sensible now, and so on. No, actually, I don't have any, because I must caveat this by explaining, Wayne, and to everybody else, I'm not a lawyer. All I'm doing today is explaining to you what I've learnt over my last 30 years of running the Complementary Medical Association, of dealing with lawyers, of dealing with trademark lawyers, of dealing with copyright, of seeing what can happen when things go terribly wrong and what can happen when things go terribly right as well. You end up building a massively valuable brand, like the CMA, for example, which is globally recognized. So, I am sort of telling you the doom, gloom and despondency on one hand, but please do remember that if you get this right and you create a really, really good brand, you could well end up with an international brand that has huge value, that you could potentially, when you come to retire, actually sell on. So, this is, there's a lot to be excited about here. So please don't run away with the idea it's all terrible and frightening, because it really isn't. So no, Wayne, I'm sorry, I can't comment on France Napoleonic law. That is something you would definitely need to speak to an expert about. And I'm not that expert. More's the pity. I'd love to know about Napoleonic law. Okay, Kane says, bless you, thanks. I'm just old and experienced. Well, yeah, we all are. We've all been in this profession for a long, long, long time. Kane says, the gentleman who started up GB Fitness, I contacted Direct and explained to him the legal issue of passing off as it can mislead people that may hire him, believing he is me, and yet he does not have the education or experience. He no doubt did that on purpose, so the threat of me taking him to court for lost earnings made him rethink. That was my fear, and that his poor service would tarnish my good work. Yeah, absolutely, I would agree with that. Absolutely. To sort of give that, that side of things as well. There was a CMA member, a lady who joined the CMA from a country in Southeast Asia. She joined as a practitioner. She took the CMA logo and put it on her products, skincare products. Now, I don't speak Thai. I don't read Thai. I don't know what was in that packaging. Can you imagine if somebody was harmed by those products and it's got the CMA logo on that packaging, sort of making it look as though we'd endorse those products? You see, that's why we would have to do, and you would have to do, a licensing agreement. And if you're doing a licensing agreement, you've got to get the lawyers in for that. You've got to get specialized licensing lawyers. You don't bear the cost of that, by the way. The person licensing your logo would bear the cost of all of that. And you've got to charge enough that you would feel happy with if something happened, and whether also the fact that they're using your logo on their branding, is that actually adding value, financial value to that product or service by having your endorsement on that. Okay, so for example, CMA members, if you're running a training school, or if you're a practitioner, or if you're running a retreat, we have specific logos for you to use. Those are our registered trademarks, and we withdraw the right to use those if you were to leave the CMA, obviously, because it implies that you are endorsed by the CMA. And because we make you jump through hoops in order to be a member of the CMA, then we feel confident in allowing you to use our trademark. And that trademark is recognized globally as excellence in complementary medicine. So it is highly, highly valuable, and it does mean that you are sporting this rubber stamping of expertise and excellence and so on. So that's why these things do have value. So I do want you to bear in mind. And then Kane goes on to say, the celebrity had been a friend of Kane's and decided to ignore my communication. So I spoke with her agent, and I think he told her the repercussions would not be worth it, especially as she's well known in the media. And Kane says, some people's blatant nerve shocks me. Absolutely, Kane, I know exactly, the celeb that lifted all my sales copy. I was really shocked and surprised, because I thought she was really good. I thought she was a very imaginative, very switched on lady. I was quite surprised that, I was flattered and yet annoyed. So there we go. But yes, I'll tell you something, actually. It's an interesting thing, guys. So one of the things that that happened to us as well, just again, I think it helps sometimes to share sort of personal experiences and where things have gone wrong and where things go right. But for example, there was a very big company in the profession. We used to produce a hard copy CMA journal every quarter. And now, of course, we've now gone with our newsletter weekly, which is actually a much, much, much better way for us to keep in touch with you. And of course, it means that trees don't have to be sacrificed for our news. But we used to run full-page ads in the journal. And there was this one company, very big company in the field, that we ran an ad for. And they then, after we ran the ad, and they had great response to it, it was a recruitment ad, they had great response to it, we sent them the invoice, and they said, well, we have decided that we'd like to pay you in products. And obviously we went back to them and said, well, we've decided that if you want to pay us in products, we're going to tell everybody in the next journal that you've offered to pay us, you've stiffed us, and that you've offered to pay us in products which we did not agree, and so on, and it won't reflect well on you. This is before social media. So the thing is, if somebody does mess you around, then you've actually got social media to fall back on, and for once, it's actually reasonably helpful. So there's that. Any other questions? I realise that we are now 5 minutes past 4, so I don't want to keep you all day. As much as this is a fascinating topic, I just want to say, is there anything else at all that I can help with, that I can answer? please just let me know. Anybody who's come into the group from way far away, Taralina, you there in Australia, and everybody who's making the effort, I just hats off to you. I cannot just thank you enough, because it confirms that these are useful sessions, and that's all I want them to be. Okay, Taralina actually says, such an eye-opening session, Jenny. Thank you so much. Lots of love for the land down under. Get some sleep, Taralina. Goodness gracious. Thank you so much for joining. Sue says, thank you very much. Really interesting. Harjit says, thank you, Janie, for the great info. Bianca says, really excellent session. Thank you very much. Janet says, it's been so interesting and I've learned a lot. Oh, well, that's wonderful. That gladdens my heart. I'm glad it's been of help. If you've got any questions, then of course you can always email. It's never a problem. Or even better, what I would like you to do, because I believe that we all tend to think of the same things and sort of think of the same questions. If you would like to put them in the CMA members Facebook group, just say, I was watching that tutorial, I just realized I've got a question about XYZ, then I'll be able to answer that as well there. And then other people will be able to chime in with their experiences, because I think group chats like this are fantastic. So if you've got questions, pop them into the CMA members Facebook group. And that's a really good way of actually sort of keeping the conversation going. Okay, so thank you so much everybody. Kane says it's really useful. Good to see you. Yes, great to see you again, Kane. We will chat. Tony says thank you, Janie. Really interesting and informative session. Tina says thank you, Tina. And our lovely Tula says thank you, Janie. Very helpful and informative as always. I shall love you and leave you, everybody. Have a wonderful weekend. Please remember that the work you're doing is so important. If you ever get to the stage where you get the sort of beginning of the year blues and you think, what am I doing all this for? Please remember, go back to your why. Remember why you got into this field in the first place, and remember, just keep shining that beautiful light out there, because you're helping so many people and your work is needed now more than ever. So please remember that. Hang on to that thought. Love to you all. Take care. Hugs. Bye.